Everyone, it's great to be here. My name is Samara Spence, and like Kristen, I am also an attorney with the Democracy Forward Foundation. I am one of two litigators representing CTFC and other plaintiffs, including the County of Santa Clara, in the Sunset Rule litigation, which is what I'm here to talk about. So for those of you unfamiliar with the Sunset Rule, it is this massive deregulatory scheme issued at the end of the Trump administration by the Department of Health and Human Services. So to really wrap your mind around what this rule is, you have to first look at what is the Department of Health and Human Services. HHS is this big agency. You heard Kristen talk about how they have a role in data collection. It also includes dozens of sub-agencies that you've heard of. It includes the Indian Health Service, the Centers for Medicare and Medicaid. It includes the FDA, which regulates food and drugs. It includes the CDC, which has played an obvious role recently in the pandemic. And then a whole bunch of sub-agencies that deal with social services for children and the elderly, including, for example, the Temporary Assistance for Needy Families program. The department has on the books roughly 18,000 regulations under its various statutes, and these cover everything from what goes on in hospitals to the safety of food and drugs, tobacco, social services. And key for our discussion, it has a lot to do with funding that tribes receive. One of the reasons for this is because under the Indian Self-Determination and Education Assistance Act, tribes are able to take over programs operated by HHS. And when tribes take over these programs, they themselves are also governed by some of these regulations, as well as regulations that control, for example, the conditions for receiving grant money. So HHS is huge and touches on pretty much everyone. So the story of the Sunset Rule starts in November, on November 4th, 2020. If you can think back to that time, COVID was surging. It was on a major upswing. The election was the day before, and we didn't even know who had won. So the world was a little bit distracted. And HHS issues this proposal announcing for the first time this massive deregulatory scheme to deregulate the entire department. So they started with the premise that there's a statute on the books called the Regulatory Flexibility Act. A lot of people have never heard of the RFA, but it basically requires periodic review of certain kinds of existing regulations, specifically ones that have a significant economic impact on a substantial number of small entities. So if a rule meets that definition, then agencies are supposed to come along every so often and decide, should the rule be amended in order to reduce the burden on small entities. But it doesn't apply to every regulation, just certain ones. So since the RFA was passed, pretty much every administration comes along and they say, yeah, I plan to review some old regulations. They all get to some, they never get as far as they say they're going to. And that's across the board, Republicans and Democrats. So HHS decides that they want to turn the RFA requirement into a threat. They propose to do this by amending all 18,000 regulations that HHS has on the books to give them recurring expiration dates. Under this proposal, the only way to prevent a regulation from expiring is for HHS to complete this two-part review of each regulation. If the regulation is unreviewed, it will just disappear automatically with no way for the public to stop that from happening. And this would apply even to regulations that are not under the RFA mandate for periodic review. According to HHS itself, only 11% of its regulations actually fall under the RFA. So thousands of regulations that are not actually covered by the RFA were subject to this proposal. The original idea was that every rule would have to be reviewed every 10 years. And all rules that were already over 10 years old would expire 2 years after the rule. So as you can imagine, people thought this was a little bit strange, but HHS finalized it anyway. It was finalized on January 19th, the day before the presidential transition. So to put this in perspective, it was entirely a lame duck rule from start to finish. No one knew about it before the election, and it was done before the new administration took over. The final version was pretty much the same as the proposal, except that the first batch of regulations would expire in 5 years instead of 2. It also included some exceptions, but nobody knows what they are because HHS didn't tell us. So under their own estimate, that would mean 17,200 regulations were set to expire in 2026. And again, we're talking about pretty much every regulation that governs healthcare, food safety, and a lot of social programs. But HHS said, well, don't worry, we plan to review these rules so they won't actually expire. Now, if I were here in person right now, I would ask for a show of hands of how many of you actually think that the department could do this in 5 years. And frankly, it's unthinkable. Depending on how you calculate it, assuming that the department could review 5 regulations in one assessment, they would have to complete 688 of them per year to do that. For comparison, in the past, the department has managed to review more like 20 to 30 rules a year. So that's assuming at least 20 times a rate increase over what they've achieved in the past. And nobody really thinks they can do that. Another aspect of this that I'd like to draw your attention to is that the process used to issue the sunset rule was, in our view, particularly insidious. So the department gave the public 30 days to comment on the proposal. If you had comments related to Medicare, you could get 60 days. But for context, 90 days is usually treated as the minimum for a typical rulemaking. And here we're talking about a rulemaking that could eliminate, for example, all Medicaid regulations, right? And they did this in the middle of a pandemic, right after a chaotic election during the holiday season. So this wasn't exactly a process designed to promote public engagement. In another aspect of this was the tribal consultation process. So as many of you probably know, HHS is supposed to consult with tribes before taking any action that will significantly affect tribes. They're supposed to do it before proposal. For a rule like this that will affect hundreds or thousands of regulations that directly impact tribes, it should have happened long before the proposal so that tribes could actually weigh in. This is not something they're supposed to do out of the goodness of their heart. It is required by law. So CTFC, as well as other tribal advocacy groups and some tribes, submitted public comments and demanded consultation. HHS flat refused, and their reasoning is inadequate to say the least. They said that the rule would have no direct impact on tribes because they intended to review all of the regulations so that they didn't expire. So that's a little disappointing to say the least. But I would like to take a moment here to emphasize how important it was that these comments happened. CTFC and other groups flagged the failure to consult for HHS. So if they had really been paying attention to that, they might have heeded the request. They didn't, but these comments did get the attention of Democracy Forward and helped us to understand that there was an issue that should be addressed in litigation. And these comments preserved the right to sue as well. So I can't emphasize enough that these comments really helped protect tribal rights. So back to sunset, despite the limited ability to comment in detail, comments came in anyway. And what's fascinating about this rule is that almost no one thought it was a good idea. Typically, you would see a lot of industry groups support deregulatory proposals. Less regulation means less hassle and less cost for them. But here, groups that would normally support deregulation said not like this. It would cause too much uncertainty. And these groups, like everyone else, didn't even have the time to figure out which regulations that affect them were going to expire. So that was not okay in their view. So we sued. We have a plaintiff coalition with CTFC and Santa Clara County and some other groups that are interested in various aspects of what HHS does. And we filed a challenge in the Northern District of California. We raised a handful of claims, including the failure to consult with tribes claim. We see this as an essential part of protecting tribal programs related to health and social services, and that's not one that we could have brought without CTFC's involvement. Those of you who are familiar with the Administrative Procedure Act, or even just listen to Kristen's presentation, will recognize some of the rest of them. There was a Twitter commenter who said that our complaint read like an administrative law exam, and there's some truth to that, because pretty much everything that could be wrong with the rule was wrong with this rule. That short comment process made it impossible for the public to meaningfully weigh in on the full impacts of the rule. HHS's reasoning was arbitrary and capricious for a number of reasons, including one that we already talked about, which is that there's no reason to believe that HHS could actually review 17,000 rules in 5 years. And then we argued that the department didn't have authority to issue a rule like this, because you can't, issue just one umbrella rule that amends all the other rules without looking specifically at those individual rules, some of which are required to be there by law. So I won't go into too much details of those claims, but if people have questions, please follow up. An obvious question here is, why did we bother to sue when Biden won the election and took over the next day? It was widely speculated that Biden would get rid of this rule. So the answer is, in part, Biden couldn't get rid of this rule overnight, even if we think that's what's going to happen. To do that, there's a notice and comment process that's required. And meanwhile, the rule was set to take effect on March 22nd, at which point the 5-year clock would start ticking for massive deregulation. So that was too much chaos for CTFC and our other plaintiffs. How could they even plan their budgets under those circumstances? And we decided to act quickly. If you're not very familiar with the APA, one benefit from suing is that it opens up options that are not otherwise available. One of these can be found in Section 705 of the APA, which says that if litigation is pending, the agency can delay the effective date of its own rule. Basically, it allows the agency to put a rule on ice so that it doesn't cause chaos while the court is looking at whether it's legal. Agencies don't do this very often. They would typically only do it if they think that they're in jeopardy of losing. You can also, under 705, ask a court to, it's called put a stay on a rule under Section 705. But here we thought that the sunset rule was so illegal that HHS should just recognize its litigation risk and do it on its own. So we wrote a letter. You can imagine how letters like this read. It's like, hi, HHS, litigator here. Y'all messed this one up. I'm about to sue you. I'm going to win. Also, this is going to cause bad things to happen in the meantime. So you should just go ahead and put this on ice. And it worked. Just in the nick of time, right before the rule was set to go into effect, HHS issued a stay, delaying the rule for 1 year. So right now, it's not set to go into effect until March of 2022. The 5-year clock is not ticking, and no regulations have expiration dates. The order itself is a really good read. I've put the citation for that in the slides. Oftentimes, these things will be pretty short on details, but here they said expressly that the court could find merit in some of plaintiffs' claims, which is basically conceding that they might lose in court. They expressly talked about our tribal consultation claim and said that our lawsuit raised questions about whether the rule was consistent with the administration's goals and policies, including engagement with tribal organizations. They mentioned the timing and said this may have impeded full and deliberate consideration of the potential issues, which is sort of talking about our process claim. And then they made a number of factual concessions, including that they no longer believe that they could actually review all of these regulations before they expire. So that was really phenomenal. They took our claims seriously, and they are taking a fresh look at the sunset rule at minimum. So that's a pretty strong signal. What now? Well, we don't have to guess, really, because HHS told us. In a recent court filing, they said outright that they plan to repeal the rule. They would not have said that if that was not a real plan, so that's great news. We think we're going to see a proposal for withdrawal in August. That showed up on Biden's spring regulatory agenda. An important flag here, like Kristen mentioned, it is really important to comment when you see these things. The department will need comments to support withdrawal. So if you didn't get a chance to comment the first time around, please consider weighing in. As for the litigation, with the rule on ICE, we eased up a little bit, and the department asked us to consent to delay the litigation, which we did. So right now it's on hold until the end of July. So at that time, we'll have to decide whether to push the litigation forward or what else to do. So that's where we stand today. It's mostly positive news. We're not there yet, but hang in there and please comment if you see a reason to.